What you see is imprint of Justice Dhananjay Chandrachud on that book. He has also been director of Maharashtra Judicial Academy, which looks after the training of judges from subordinate courts. As a judge of Supreme Court, he has written innumerable judgments which I cannot mention at this place for want of time. I will mention only 3 judgments, and those judgments are the dissenting judgments which will, I am certain, one day will be the law of the land. In entry tax the validity of entry tax laws, a bench of 9 judges, Justice Chandrachud's erudition and the regard and respect for principles and traditions came out in his dissenting judgment, where he confirmed the previous judgments in automobile case and the Atia Bari case, the old judgments under Article 301 of the Constitution of India. The second judgment I must mention is the judgment in Aadhaar case, and the third judgment I must mention is the judgment in relation to freedom of speech and expression. And I quote from his judgment on freedom of speech and expression. He said, "Freedom of speech and expression is elan vital of sustenance of all other rights and is seed for germinating democratic views. Plurality of voices celebrated constitutional ideas of liberal democracy and should not be suppressed. Intolerance arising out of dogmatic mindset has chilling effect on freedom of thought and expression." Now, I am certain these are the resonating words which will be seen, and the judgment would perhaps one day become the majority judgment. His justice-oriented approach, at times even treading on unbeaten path, follows Lord Atkin's dictum, who said, "Finality is good, but justice is better." That's the approach Justice Chandrachud adopts in all his judgments. He is known as one of the best and brilliant writers of the judgment. When he was in Bombay High Court, when we argue a case before him, he would take down his notes in a very, very short letters. And thereafter he would dictate the judgment in open court. And we would feel that we probably have argued this case in such a good manner, which of course was his erudition and not the erudition of our arguments. So he would make you feel that you have argued that case in an extremely well manner. That is his judgment writing skill. I think I can say with certainty that arguably he is the best writer of judgments today in the country. We are fortunate to have Dhananjay Chandrachud with us this evening to deliver the K.T. Desai Memorial Lecture on a subject very dear to him, why the Constitution matters. And as I said earlier, who else to deliver subject on that subject? We are all anxious to hear Justice Chandrachud. I once again welcome Justice Chandrachud in our midst. Welcome home. Thank you.
Dr. Chandrachud. Just be careful of the steps.
Thank you, Dr. Sathe, for those very noble and kind words. Chief Justice of the Bombay High Court, Justice Naresh Patil, my distinguished brother and sister judges of the Bombay High Court, Chief Justice S.P. Bharucha, former Chief Justice of India, Justice Sujata Manohar, Mr. Vasant Manohar and members of the family, distinguished former judges of the Supreme Court, Justice Sam Variawar, Justice Hemant Gokhale, Chief Justice Mohit Shah, Chief Justice Shavak Swajivdar, Mr. Milind Sathe, Mr. Rajiv Patil, former judges of the Bombay High Court, distinguished senior advocates and members of the bar, ladies and gentlemen. It is a great honor for me to address this august gathering this evening at the Justice K.T. Desai Memorial Lecture, not just because this is my parent court and some of my most treasured moments associated with the profession have been in these premises, but also because this lecture has been organized in the memory of an individual whose contributions to public life provide a beacon to judges and lawyers who continue in that tradition. Justice Desai, Kantibai as he was fondly called, was born in May 1903 in Mumbai. He cleared two really difficult examinations, the solicitors and the advocate on the original side in 1928 and 1930, a rare achievement in those times. He practiced on the original side of the Bombay High Court and was considered an eminent draftsman. Invited to the bench by Chief Justice Chagla, Justice Desai accepted judgeship with the knowledge that he had only 6 years at the bench, leaving a lucrative practice at the bar. In those days, to be invited by Chief Justice Chagla was itself a distinction. Judges of his genre placed the fundamentals of commercial law on a sure foundation in Mumbai and beyond. Justice Desai's daughter, Justice Sujata Manohar, has carried forward his legacy in public service, having been appointed the first female judge of the Bombay High Court, as well as its first female Chief Justice. She was subsequently elevated to the Supreme Court, a court which she served with distinction, independence, and an unwavering sense of personal integrity. Ma'am, you've invited me to deliver this lecture, but it's a tall order to do so in the presence of Chief Justice Bharucha and your presence. I've appeared before both of you in this very court on numerous occasions. I'd only like to begin with two little personal anecdotes. Justice Sarosh Kapadia had become a judge of the Bombay High Court. It was 92. And he used to appear for a very leading public sector corporation. I used to appear as his junior. After his elevation, the time came to test me whether I would be able to continue the mantle of that brief. And we were appearing before a division bench of the Bombay High Court in this very court, presided over by Justice Sujata Manohar. I was opposed by Mr. K.K. Singhvi, the doyen of the Labour Bar and the bar in general. At the end of a very long argument, Justice Manohar, with her characteristic nod of the head, said, "Rule, but no interim relief." The words, "no interim relief," were music to the ears of my clients, which meant that I got that brief for the next 10 years before I was appointed as a judge, I think in 2000. And speaking of Justice Bharucha, I appeared here when he was presiding over the court as a judge in charge of notices of motion. My arguments were proceeding in an even tenor when the instructing advocate said something to me, and I blurted it out to the court. And Justice Bharucha looked at me very sternly and said, "You're not his master's voice." What happened to the rest of my argument is now a very blurred memory, because a junior normally shakes when something like that is shown to him or her. But I think we cut our teeth, we learnt our first faltering steps in the shadow of these two great judges. And one of the reasons why I have prepared a speech contrary to my own instinct to deliver an extempore speech is because I'm quite overwhelmed by the importance of this occasion. I'm extremely grateful to Justice Sujata Manohar for inviting me to speak today on a subject which is close to my heart, the Indian Constitution. Although it does give me some leeway to conclude, or at least put forth an adverse view, that constitutions do not, or perhaps may not matter. Doing that would firstly have us confronting the perils of the collapse of our constitutional democracy, and secondly, for me, the peril of being out of my own job. So let me begin by stating which side of the line I stand. Our Constitution does matter. The Indian constitutional project did not commence on 9 December 1946, when the Constituent Assembly sat in New Delhi for its first session. It first echoed in the battlefields of Bengal in the 1857 rebellion. Lokmanya Bal Tilak, whose famous trial took place in this courtroom, was among the first to call for Purna Swaraj. For many decades prior to the coming into the force of our Constitution, the Indian self-rule movement was a mass movement and encompassed many sections of society. The call was simple: a governing document of the people, by the people, and for the people. The constitutional culture in India predated the coming into force of our constitution. Before the advent of our constitution, a well-known demand had emerged to establish, through the participation of the people, basic rules and principles of behavior which would constitute universally binding legal norms. The Constitution was to mark a transfer of the power to steward the destinies of its citizens. So the first important facet of the Constitution which I want to emphasize, that this is a document which marks the transfer of colonial power. The Constitution was to put in place an organic structure that would sustain the country's independence and freedom, equipped with the tools for social revolution, as noted historian Granville Austin called it. So a parallel movement was taking place during the times of the freedom movement, which we shouldn't lose sight of. The parallel movement, together with the movement for freedom, was a movement for social emancipation. The movement which was begun by people like Dr. B.R. Ambedkar, but even before Babasaheb Ambedkar, by people like Phule. This potential of a constitutional document in steering the course of the society it governs lends it paramountcy in comparison to statute law. A quote by Carl Schmitt comes to mind. The essence of the Constitution, he says, is not contained in a statute or a norm, but in a prior and fundamental political decision by the bearer of the Constitution-making power. In a democracy, this is a decision by the people. A constitutional culture is based on the understanding that a constitution unifies a population beyond those in one's immediate sphere of acquaintance, and that whatever be our differences, this is something we have in common. When the Constitution was adopted, there was a consciousness that in writing its text, India was finding a way to resolve major substantive debates and disputes over norms and values. In granting people power over their destiny, the Constitution placed the individual at its heart to guide the functioning of the democratic institutions which it has put in place. Our history of constitutional drafting is replete with anecdotes which illustrate that there was an attempt by the framers to stake ownership over that document. Our framers did not place the Constitution for approval before the British Parliament. Following the Irish precedent, Article 395 of the Constitution repealed the Indian Independence Act. The framers repudiated the source which authorized them to enact the Constitution. This was a symbolic denial of Indian independence being a benevolence of an imperial parliament. These actions of the framers ensured that the chain of constitutional validity did not extend to the crown in parliament. They delivered a completely, pardon my long word, they delivered a completely autochthonous constitution, a homegrown constitution rooted in our soil. The Constitution owed its validity and authority to its own people, rather than to the fact of its enactment by a foreign legal process. In way fashion, we the people, through the members of the Constituent Assembly, came to be the source of authority of the Constitution, rather than the Indian Independence Act enacted by the British Crown in Parliament. The advent of the Indian Constitution thus marked the coming together of a population, the culmination of a desire for self-governance. It represented a bottom-up approach where the people granted to themselves their structures of governance. In Nani Palkhiwala's words, the Constitution represents the charter of power granted by liberty and not the charter of liberty granted by power. Liberty is not a gift of the state to the people. It is the people enjoying liberty as citizens of a free republic who have granted power to the legislature and to the executive. The Constitution was required to take into account multiple conflicts. Let us understand that this is a Constitution which is founded in a history of multiple conflicts. Freedom of expression and national integrity, personal liberty and political stability, special treatment for some segments of society and equality for all, property rights and social revolutionary needs. the people who work the Constitution may go terribly wrong, and sometimes they do, as when we jail a cartoonist for sedition, or when jail instead of bail is given to a blogger who is critical of our religious architecture. When a mob lynches a person for the food that she or he eats, it is the Constitution which is lynched. When we deny to human beings the power of love for reasons of religion or caste, it is the Constitution which is made to weep. That is exactly what happened yesterday when a groom belonging to the Dalit community was asked to climb down from a horse in a wedding procession. Let us make no two bones about it. There is the Constitution which weeps when we read of such incidents. To the wisdom of our people, the Constitution trusts. The trust is broken at our peril. The most fundamental struggle was between Parliament and the Supreme Court over custody of the Constitution, the central issue being whether Parliament's power of amendment was complete and unrestrained. In the initial decade of the Indian independence, of the nation's independence, a stronger central government with far-reaching powers had assumed importance in order to drive socio-political revolution. The birth of the nation was into what Granville Austin has described an emergency. Two decisions immediately fueled a change in the Constitution. The decision of the Supreme Court in Ramesh Thapar versus State of Madras, striking down the Madras Maintenance of Public Order Act, 1949, and Brij Bhushan versus State of Delhi, striking down the East Punjab Public Safety Act, immediately prompted the need to insert the word reasonable in Article 19(2), as well as new grounds of public order, friendly relations with foreign states, and incitement to an offense in order to allow the state to regulate free speech. One other article into the Constitution reflected the centre's concern to centralize power through the Constitution and enact property legislation. By the First Amendment, Article 31A and 31B were also added to the Constitution, which expressly saved laws providing for the acquisition of estates from being void on the ground that they are inconsistent with fundamental rights. Acts and regulations specified in the 9th schedule would be immune from the operation of Article 13. In keeping with the tense atmosphere into which India was born, the operation of the preventive detention law brought into focus a jurisprudential position by the Supreme Court, which was deferential to the state. This was clearest in A.K. Gopalan versus State of Madras, where the majority held that Article 22, being a complete code relating to the preventive detention law, the validity of an order of detention must be determined strictly according to the terms and within the four corners of Article 22, and that its validity cannot be tested against Article 19 and 21. In other words, the fact that the fundamental rights were not a continuous stretch of entitlements, but isolated pockets of discrete rights was the jurisprudence of our court, or the Supreme Court at that time. So the working of the Constitution in the first decade of its existence, in the context of a newly born nation looking to consolidate national unity, was characterized by deference to the state agenda. But to the exigencies of time, the Constitution adapted and endured. A developing body of comparative constitutional studies studying the resilience of constitutions has indicated that there are three features that exert an overwhelming bearing on their endurance. The first is inclusiveness of the Constitution. The second is